judgment in the field being on the application of Ingenious Media Holdings and Commissioners for Majesty's Revenue and Customs.
The judgment in this case was written by Lord Toulson, with whom the other justices all agree, but unfortunately he cannot be here today. The case is about the duty of confidentiality owed by Her Majesty's Revenue and Customs towards taxpayers in relation to their tax affairs. This is an example of a well-established general principle that where personal or confidential information is obtained by a public body in the exercise of its powers and duties, that information is not to be used for other purposes. The Revenue's duty of confidentiality has been put into statute in Section 18 of the Commissioners for Revenue and Customs Act 2005. One of the exceptions is for, quote, disclosure which is made for the purposes of a function of the Revenue and Customs, end quote. Mr McKenna is a chartered accountant and the founder and chief executive of the Ingenious Media group of companies, whose activities included promotion of film investment schemes using forms of tax relief. The marketing of the schemes stopped when the availability of the tax relief was ended. In June 2012, the Permanent Secretary for Tax, Mr David Hartnett, gave an interview to two financial journalists from The Times. They had asked for an interview on the subject of tax avoidance, and it was agreed that it would be off the record. A few days later, The Times published two articles based on the interview. The articles named Mr McKenna and reported statements made about him by somebody described as a senior revenue official. It was said that Mr McKenna represented a threat to the revenue, that the film schemes promoted by him and another person had enabled investors to avoid at least £5 billion in tax, and that the revenue would like to recover lots of tax relief he had generated. Mr McKenna and his companies brought these proceedings against the revenue on the basis that it had breached its duty of confidentiality towards them. The reasons given by Mr Hartnett for revealing the information to the journalists were that it was in the interests of the revenue to establish good relations with the press, that it was a way of publicising the revenue's views on elaborate tax avoidance schemes, and that he thought that the journalists might reveal information of significant value to the revenue, for example, about tax avoidance schemes of which the revenue was unaware. Mr Hartnett also emphasised that the interview was supposed to be off the record. The courts below held that the revenue were entitled to consider that the disclosure was for the purposes of their functions. The Supreme Court disagrees. It does not accept that Parliament, in using the broad language, a disclosure made for the purposes of a function of the Revenue and Customs, intended to give officials a general discretion to disclose confidential information, limited only by a rationality test, in place of the ordinary principles of confidentiality applicable to public bodies. To allow officials to discuss their views of individuals with journalists whenever the official thought that it would be expedient for some collateral purpose would significantly emasculate the primary duty of confidentiality established at common law and recognised in the 2005 Act. The proper interpretation of this exception is that it permits disclosure of taxpayer information to other persons to the extent reasonably necessary for the revenue to fulfil its primary function. The Supreme Court also disagrees with the courts below about the court's proper role in this area. It is for the court to decide whether there has been a breach of the duty of confidentiality, applying the law to its own judgment of the facts. The courts below approach the case on the narrower principles of judicial review of administrative action. But these do not occupy the entire ground whenever the conduct of a public body is under challenge. Public bodies are not immune from the ordinary application of the common law, including, in this case, the law of confidentiality. The information given by Mr Hartnett to the journalists about the affairs of Mr McKenna and his companies was not necessary for the purpose of investigating the schemes to which it related, and the reasons advanced for doing so are far too tenuous to justify the breach of confidentiality. Finally, it makes no difference that the interview was agreed to be off the record. While there may be circumstances in which disclosure of confidential information may be permissible on a restricted basis, An impermissible disclosure of confidential information is no less impermissible because it is passed on in confidence. This is typically how secrets are spread. The appeals are therefore allowed.